For many people, getting indefinite leave to remain or ILR in the UK has long felt like the end of a long, often stressful journey. After years of visa fees, paperwork, uncertainty, and navigating a complex immigration system, finally securing settlement was supposed to be the final milestone. The next step, applying for a British passport, was traditionally seen as a formality, a confirmation that you truly belonged in this country. But in 2025, that certainty no longer exists. The path to citizenship has become far more complicated and, in many ways, far more dangerous. It is no longer a single, straightforward step. Instead, it is a minefield filled with hidden traps, unwritten rules, and complex requirements. Even the most deserving applicants, those who have followed the rules for years, can be disqualified at the very last moment. These hidden obstacles, sometimes called citizenship bans, are designed to catch people off guard, creating uncertainty at a point when many believed they were finally safe. Believing the ILR makes you automatically safe is now one of the biggest risks an applicant can take. The Home Office is approaching citizenship applications with far greater scrutiny than ever before, using both traditional checks and modern data-driven tools to examine an applicant's entire history. Let's start with what immigration experts call the good character time bomb. Every citizenship application requires proof that the applicant is of good character. In the past, many people with ILR assumed they had already passed this test, reasoning that you cannot obtain ILR with a serious criminal record. However, the Home Office now treats the citizenship application as a complete forensic review of an applicant's life in the UK. Even minor past issues that were once considered irrelevant or resolved can now be used to deny citizenship. For example, a fixed penalty notice for a driving offence from several years ago, a small tax discrepancy that was resolved with HMRC years before you received ILR, or even a brief period of accidental overstaying between visas can now be grounds for refusal. ILR does not erase past mistakes. The Home Office can re-examine every record they hold and may refuse your application if they feel any action shows a lack of respect for the law. In essence, applicants are being judged today for mistakes made years ago, even if those issues were already forgiven or resolved. This time bomb effect turns the good character requirement into a source of real risk at the very end of a long immigration journey. Next is what some experts refer to as the digital ghost and the travel ban. To qualify for citizenship, applicants must prove their residence in the UK. This includes strict rules about how much time they have spent abroad. There are limits on the total number of days spent outside the country over the 5 years before applying, and an even stricter limit in the final year. Going over these limits by even a single day, perhaps because of a family emergency or a cancelled flight can, and often does, lead to refusal. There is very little discretion, and exceptions are rare. The real complexity comes from the digital ghost. The Home Office no longer relies solely on passport stamps to track travel. Today, officials can build a detailed digital picture of your life. They can access flight manifests, bank transactions that show card use abroad, and even your social media posts. If any of this information contradicts the dates you provide in your application, you may be flagged. Applicants who cannot account for every trip with perfect accuracy may be accused of deception, automatically failing the good character requirement. In short, your own digital footprint can haunt you, and any small inconsistency can destroy your chances. Meticulous record-keeping has become a critical requirement. Another major hazard is what immigration specialists call the financial inquisition. Citizenship applicants are now subject to a deep dive into their financial history. The Home Office cross-checks data with HMRC and investigates past employment, income, and even minor tax errors. They are looking for any discrepancies, however small. Past mistakes such as undeclared cash work, minor self-assessment errors, or even involvement with a company that later had compliance issues can be used as evidence of dishonesty. The burden of proof is entirely on the applicant. Any mistake, no matter how minor or unintentional, can be interpreted as financial misconduct or even tax evasion. Imagine a freelance consultant who 6 years ago received a modest payment from an overseas client and recorded it incorrectly, resulting in a small underpayment of tax. Even if HMRC never contacted them, the Home Office may flag this during a citizenship review, potentially leading to refusal. Applicants are being held to a near impossible standard of financial perfection. Closely linked to financial scrutiny is the association risk. The good character requirement now extends beyond an applicant's own actions to the people they know or interact with. Applicants can be denied citizenship because of their links to others deemed to be of bad character. This does not only include close friends or family with criminal records. It could also include former business partners investigated for fraud, tenants involved in illegal activity, or even casual acquaintances. One of the most troubling aspects of this risk is that the Home Office may use intelligence or evidence that is not disclosed to the applicant, citing national security or confidentiality. This means someone could be denied citizenship because of another person's actions, and they might never know the exact reason why. The consequences can be chilling, forcing applicants to scrutinize every personal and professional relationship. Even lifelong achievements can be jeopardized by someone else's wrongdoing. Finally, there is the future intentions requirement, a highly subjective and forward-looking test. To naturalise, applicants must declare that they intend for the UK to be their primary home. In the past, this declaration was largely taken at face value for ILR holders. Now, the Home Office actively looks for evidence to contradict this statement, searching for signs that someone may be seeking citizenship primarily for travel benefits while planning to live elsewhere. The evidence considered can be surprisingly mundane. Owning property abroad, having family living overseas, or even social media posts about future plans can be used to question an applicant's commitment to the UK. Innocent remarks about travel, retirement, or work plans in another country can be interpreted as evidence that the UK is not your main home. In essence, applicants can be denied citizenship based on speculation about their future intentions, even after years of proven commitment. So, what can applicants do to protect themselves in this new environment? Experts stress the importance of preparation. Start by reviewing your personal history carefully. Collect and organise all relevant documents, including driving records, tax transcripts, payslips, bank statements, travel tickets, boarding passes, and correspondence with official bodies. If past mistakes exist, obtain proof from the relevant authority that they were resolved. Keep receipts for fines paid and letters confirming tax adjustments. Prepare clear and factual explanations for any incidents that may appear during background checks. Pay attention to your digital footprint. Ensure travel records, passport stamps, and bank statements match. Gather supporting evidence for necessary trips, such as medical notes, funeral notices, or employer authorizations. Review social media accounts and remove posts that contradict your stated intentions or travel history. For financial issues, seek professional guidance from accountants to correct any past errors and document your good faith actions. If you have complex corporate histories or were a director of a company, gather final accounts and official confirmations showing the outcome of any investigations. If your associations could be questioned, collect contracts, tenancy agreements, business records, and proof of due diligence. In cases where confidential or intelligence-based material is involved, legal representation is essential. Immigration lawyers can make confidential enquiries and challenge secret evidence when possible. Finally, if you believe a citizenship decision is unfair or based on hidden material, seek regulated legal advice immediately. Some decisions can be appealed or challenged via judicial review, but others, especially those involving confidential intelligence, are more difficult to contest. Early specialist support significantly increases the chance of a successful outcome. In today's immigration landscape, rules are applied in a more intrusive, data-driven, and subjective way. This makes the final step to citizenship the most sensitive and vulnerable part of the entire journey. Preparation, meticulous record-keeping, honest disclosure, and professional guidance are critical to reduce risks and strengthen your application. Citizenship may no longer be a formality, but with careful planning, Applicants can navigate these hidden traps. Review your history, organise your records, and seek professional advice if anything is unclear. Knowledge and preparation are the best tools for safeguarding your future in the UK.